The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
Today we're going to talk about real property. So previously in Business Law 1, you discussed personal property. Well, today we're going to really cover real property, and we have to know what is real property. Real property will include land, buildings, fixtures, and the rights in the land of another. Land includes things embedded in or attached to it, and it can include things like water, herbs, grass, and so forth. A landowner generally will own the space above and below their land. Now, a person may have the right to use another's land, and this is known as an easement. The land that is benefited is the dominant tenement, where the land that is subject to the easement is the servient tenement. Easements may be oral or written. An easement can be created by necessity, as when property is landlocked, or by prescription, when the easement is acquired adversely. In addition, easements may be created by estoppel. Once the easement has been granted, though, the Grantors Act can't destroy it, but the easement may be lost for non-use. If you look at the following diagram, we've kind of drew a thing of your house and your neighbor lives behind you. But in order for the neighbor to get to their property, they had to go through your lot because there was no entranceway any other way when they had built their house back there. So you had granted them an easement from your property in order to get to their property. Once they abandoned that easement, let's assume behind them there were trees and those trees were cut down and now they could enter their house from that way, and they choose to do that, and they stop using the easement you had granted them, they would lose that because of the abandonment. Let's talk about some other things too, such as profits and licenses. What are profits? Profits are going to be the right to remove something from the land of another. So let's go back to the diagram for a minute and let's talk about your pond. Maybe you had fish in the pond and you gave somebody the right to go and remove the pond from your, the fish from your pond. Okay? Another aspect could be a license. Licenses are going to be revocable privileges to be on the land of another. The licensor may terminate the license at will and will continue for as long as the licensor owns that land. Licenses are different from easements in that licenses are not an interest in the land. So even if you sold your house, the easement would still exist for your neighbor if that's how they were getting to their house. It would not automatically die with the land. If, however, you granted your neighbor a license in order to maybe say go fish in your pond or swim in your pond, if you sold your house, that license would be revoked and they'd have to get permission from the new owner in order to go swim in that pond or fish in that pond. Okay, let's talk about liens for a minute. Liens are going to be claims or rights against property and can be foreclosed in the event of non-payment. These claims are voluntary acts where the owner uses the land as security for loans. So, for example, mortgages. You can also have involuntary liens. Examples of these would be like mechanics liens, judgment liens, or even tax liens. We said that real property may consist of fixtures, but what are fixtures? Fixtures are personal property that have been attached to the land. So the determination of whether an item is a fixture is going to be determined by several tests, such as the degree of annexation, adaptation, the intent, and whether the machinery or equipment is movable, and whether the item is a trade fixture. So what happens? Think of your house for a minute. Sometimes you'll have an air conditioning unit. And depending on how it is done, sometimes the courts will find that those window air conditioning units are actually fixtures. Because if you take it and remove it, it could damage the structure of the house, things like that. So they might deem it a fixture that you would have to sell it with the house. Sometimes they could be movable where they come out and it's done no damage or anything and it's not so affixed in that window and stuff where they'll say, okay, that's personal property, you can go ahead and remove it. Another thing that I will tell you is sometimes when you're selling property, if there's things that you don't want to sell, like say a really nice chandelier, before you sell your house, you either should take that chandelier down because otherwise it would be deemed a fixture, or you can at least put it in that purchase sale agreement that is excluded from the sale so that they know up front that you are not selling it. A person's interest in real property can be a freehold estate, such as a fee simple or a life estate. Now, these estates are known as freehold estates because they are of interest of uncertain duration. If the person owns the property for a specified period of time, it will be a leasehold estate. We said there were things such as fee simples or life estates. Fee simple absolutes, or estates in fee will last forever, which is when the owner has the absolute and entire interest in the land. There are certain characteristics here. They are: it is alienable or transferable during life, it's alienable by will, it passes to the owner's heirs if it isn't transferred by will, it's subject to the rights of the surviving spouse, and it can be attached or used to satisfy debts of the owner before or after death. Fee simple defeasibles give a grantee all the rights of a fee simple holder, provided that the grantee complies with certain restrictions. So here, an example of a fee simple defeasible is maybe I let you use the property as long as you use it as a golf course. The minute you stop using it as a golf course, you are no longer complying with that restriction. What would happen is it would revert back to the grantor then, and you would no longer have that fee simple defeasible in that property. Now let's talk about life estates for a moment. What is a life estate? A life estate will last for the person's lifetime, but upon the death of the person whose life was measured, the owner of the life estate loses any interest remaining to pass to heirs or by will. If a person has a future interest in the in the land, that interest is going to be known as a remainder interest. If the grantee violated the restriction maybe that's provided in the life estate, then the grantor has the possibility of reverter. There's another area of law that deals with the landowner's liability to third parties, and if those parties are injured on the landowner's property. At common law, third parties could be seen as either trespassers, licensees, that I'll also call social guests, or invitees, or also called business invitees. The higher degree of invitation for the land occupier, the greater the duty that was owed to that person. Now, generally, the rule is going to be that a landowner is not liable to trespassers. So, rule number 1, no duty is owed to a trespasser. However, if the trespasser is a child, then under the attractive nuisance doctrine, the landowner does have a duty to warn or control the child's access. We're talking an attractive nuisance. Go back to the picture for a moment. Look at the pond. Say you have a child wanders onto your property because they see that water. What duty do you owe to that child then if the child now goes to the pond and ends up drowning and dies in it, or is injured while going to the pond? Generally, we said if it was a trespasser, you would know no duty. But because this was a pond, it's a attractive nuisance, you might owe a duty to the child. And under the attractive nuisance doctrine, you would actually have to look at all the elements, because it actually, one of the elements you'd look at is it a natural pond or is it a man-made pond? Because that might also determine whether or not you're liable under that attractive nuisance doctrine. Now, if the third party happens to be a licensee or a social guest, as I called it, you invited someone over, just to hang out, the landowner does have a duty to warn of non-obvious dangers that landowner is aware of, and they must warn the guest of those dangers. The landowner doesn't, however, have a duty to learn of the presence of any unknown dangers. If it is an invitee or business invitees, and they enter the land by invitation, so think customers for a minute, and the owner here will have a duty to take reasonable steps to discover any known danger, and it has a duty to warn the invitee of that danger or to correct it. Think your grocery store. Why do you think you see those little signs that say caution wet floor? Even though everybody knows that the floor is wet because they see the puddle laying on the floor. It's because here it's the customer coming in, the property owner, store owner, right, owes that customer a higher standard of duty of care, so they have to warn them of those dangers that they are aware of, okay? And they also have to try and correct it. Now, modern courts are changing this, and they're ignoring these common law distinctions between classes, and they're merely holding owners liable for any ordinary negligence standards. Here, you'd have to make sure just to see what your jurisdiction is following, whether they're following the common law or they're tending to follow more of the modern. Recreational use statutes will provide immunity from liability to persons using the property for recreational purposes for no charge. As you may recall from Business Law 1, you may also hold real property with several parties. We'll have things such as tenants in common, joint tenancy with rights of survivorship, or joint tenancy as you'll hear it called at times, tenants by the entirety, and community property. Another area you should be aware of is condominium and cooperative. Those are also a combination of co-ownerships, and ownership in the condominium is going to be different than from our ownership in the cooperative. Now, the transfer of property can occur by deed, which is a written instrument from a grantor to a grantee. And the type of deeds include the quitclaim deed and the warranty deed. Deeds require delivery and acceptance for that transfer to take place. Recording is not necessary to effect a transfer, but it does protect the parties against future transfers and conflicting titles. So the recording of deeds are one of three things. It depends on your jurisdiction. You'll either have race statutes, notice statutes, notice race, or race notice statutes, depending on what that jurisdiction calls it. What is the distinction between the three? If it's a race statute, then the first party to record has title. If it's a notice statute, it's the last good faith or bona fide purchaser who takes title. And if it's a notice race or race notice statute, it's the first bona fide purchaser to record the deed holds the title. If you look at pages 1011 through 1013, that talks about these different types of recording statutes of the deeds and stuff. I would look at that example. That's a really good example to show you how they all work on there. Now, the grantor makes the following warranties when they transfer land. So they'll make the warranty that the grantor owns the title, the transfer is proper, there is not any encumbrances other than those that were noted, and the grantor will not do anything to interfere with the title. Covenants by the grantee can run with the land, or they can become a part of the title to the land and may include, for example, an affirmative easement. Real property may also be transferred by adverse possession or by eminent domain. A person who complies with certain physical and time requirements may acquire possession to property through adverse possession. When we're dealing with adverse possession, you must show that the possession was actual, visible and notorious, exclusive, hostile, and continuous for a stated period of time, which may range from 10 years to 20 years. So you really have to look at what state you're in. Michigan is the continuous period of time is 15 years. Eminent domain is where the government or a public authority takes property from a private owner for a public purpose. The Fifth Amendment of the U.S. Constitution governs eminent domain matters, and it requires that private owners are entitled to just compensation for the takings. The last area of the textbook deals with mortgages. Mortgages are liens on real property, and these can be foreclosed upon and are used as a security for a loan. Upon default, the mortgagee can sue to collect on the underlying contract or foreclose on the mortgage. Here, if you're thinking of mortgages, think mostly you have a mortgage on your house. The bank, is the mortgagee. You're the mortgagor. You don't pay them, and guess what? They can come back now and take your house. That has been Chapter 48 in a nutshell. If you have any questions, please let me know.
Good luck with today's lesson.